the results such, Mr. Bernard, that you think it's a reason that the case should not proceed against Mr. Jordan at this time?
I think so, Judge.
Okay.
That's correct.
So
Yes.
then, Ms. Patel, as I've experienced this, you, of course, have an opportunity to, hold on one second. I had to get the Zoom channel going. It's going. There's always an opportunity to get a second opinion, although typically what happens when we get these results from these medical professionals, then there's a question about whether we're going to engage in a restoration program. Mr. Jordan is out, and so that is a different set of circumstances than if someone's in custody, because if someone's in custody, usually the defense attorney submits an order, and we have the defendant transferred to the custody of DBH/DD. But it happens that sometimes the defendant's out on bond. So it may make sense for Ms. Patel, you to talk with your colleagues about what you'd want to see happen next, and then confer with Mr. Bernard, and we'll see what makes the most sense. I think the right next step is to see if there is a restoration plan that could be pursued in an outpatient setting, because Mr. Jordan is on bond and doesn't seem to have had any issues while on bond. At least I haven't seen any reports suggesting to the contrary. And then we'd see if the results of the restoration assessment or analysis are that's not something that's going to work out, or under a certain regimen, Mr. Jordan could be in a position to assist Mr. Bernard in moving forward.
Yes, and so I actually, coming onto this to court today, I assumed that there would be some sort of restoration program that his evaluation had given him, because typically they do list that in the actual report, but I didn't see that in this report. I just pulled it up. So yeah, I guess if we can just talk about the next step, Bernard, I think that would be the state's recommendation, is to just do whatever is appropriate for a restoration program.
Okay. Mr. Bernard, do you have any experience in working through this process when your client is on bond as opposed to in custody?
Judge, I don't when they're on bond. However, I think that and Ms. Patel and I'll talk about this. I think restoration in this particular case is probably going to be difficult because of the way in which the injury occurred. But we can talk about that and see if there's a restoration plan that could work in this case.
Okay. Why don't we do this? My thought is we're going to take Mr. Jordan's case off the trial track, put it on a side track, and get him on a status calendar, maybe a month and a half out. I'll try to remember, and I'll have Ms. Nelson try to remember, Mr. Jordan does not need to appear for that status calendar. It will be an opportunity for Ms. Patel and Mr. Bernard to share with me what they think any next steps are. But without going into lots of detail in this public setting, if Mr. Jordan's situation is driven more by a traumatic injury, it may be that it's not a situation that unfortunately can be ameliorated in any way. But that's a good conversation for Ms. Patel and Mr. Bernard to have offline, and then report back. So we'll reset this for a status hearing in late April, early May. Like I said, month and a half out, and we'll try to remember to let you know, Mr. Bernard, that Mr. Jordan doesn't need to join us, and we'll have a discussion.
Okay.
Does that work for you, Ms. Patel?
Yes, thank you, Your Honor.
Okay, Mr. Bernard, does that work for you?
Yes, Judge. We appreciate it.
All right. Thank you, Mr. Jordan, for joining us. You are free to go, okay? Be safe.
Thank you, Judge. I think that's all of my cases as well. May I be excused?
Yes, sir.
All right, thanks.
Ms. Hall, or Mr. Franklin, good morning, Mr. Franklin. Do you all mind taking attendance, meaning figuring out who is in the gallery? I think some attorneys who are plugging in online are wondering if their clients are there.
Kimber. Yeah, there's a Mr. Kimber present.
Great. I think that's Ms. Rockwell's client. She was asking if he was there.
And Mr. Dewar, my client, he's standing in the hallway for a moment.
Okay, great. So yeah, Mr. Kimber is position 8 and 9, and Dewar is 7. Okay, great. So that gets us to position 2, which is State versus Hines, another final plea. Do we have, well, we have Ms. Patel. Good morning, Ms. Patel. Where's Ms. Hines?
Good morning, Judge. I don't know if she's not in court. I don't know if she will be appearing.
Okay. Do you have reason to expect her in court, or have you had trouble contacting Ms. Hines?
I spoke to all her family members who were supposed to get in touch with her for me. That was about 2 weeks ago.
Okay.
I no longer have a good number for her.
Okay. Does her family have a way to contact her, or that's just sort of your last best option?
That is my last best option. They told me she was staying with a cousin, so that they made it seem like it would be easy for them to get in touch with her, because they see this family member regularly. But I haven't had any luck with the family in terms of them getting the message to her about court.
Okay. So my thought is that we get a bench warrant for Ms. Hines, but you are able to make contact Ms. Patel and can walk her in. We can handle that a different way, but otherwise we need to make sure there's a way to get Ms. Hines back on track if she comes into contact with anyone who could help with that. Ms. Hall, is that all right with you?
Yes, Your Honor.
Okay. All right. So again, Ms. Patel, if you do get word from her family or she reaches out to you, just let Ms. Nelson know on date X, Ms. Hines and I are coming on in, and we'll handle that in a different way than if we learn that she's at Union City.
Yes, Your Honor.
All right. That gets us to position 3, Kendrick Lewis. My notes say that there's a bench warrant on, and I don't know. Oh, so did we reset this to make sure he got notice, or what's going on with this?
Yes, that's correct, Judge. We reset for notice.
Okay. Any update, Ms. Patel, on Mr. Lewis?
Your Honor, the pre-trial compliance report indicated that he was in custody in Irwin County Jail. They don't have a standard inmate lookup system that I can use online to verify if he's still there. But that was the latest update from pre-trial. It was a shoplifting offense. Since there is a pre-trial warrant in place, Your Honor,
Sorry, I can't hear.
Hold on one sec. Hey,
There's
Ms.
some
Hall,
background.
Ms. Hall, are you able to mute your microphone?
Oh, I'm sorry.
No problem. Just you're free to chat with whoever's sitting next to you. It was coming across. Okay. So Irwin County, unsurprisingly, they don't have a robust online system to see who's in their small county jail. So my thought is that we issue a bench warrant, but if you are able to confirm by calling Irwin County to see if there's a Kendrick Lewis stuck down there, we can always figure out a way to try to get him up here from there.
There is a pretrial warrant supposedly in place.
Okay.
I will call them and see. I just want to, in the event he's in custody, I just want to avoid another FTA appearing on his record.
Okay.
But I will see if I can get in touch with someone in Irwin County.
Ms. Nelson, does the pretrial bench warrant serve the same function as if we issued our own bench warrant because he did not show up?
The pretrial bench warrants will remain, and so they would pick them up on the pretrial bench warrant. We would just be putting another warrant in, which, like Ms. Patel had said, it's just a duplicate warrant.
Okay, I don't mean to do that then. If there is a warrant that would serve the purpose of getting Mr. Lewis to us, if he came into contact with law enforcement, we don't need two of them. So I guess we will just leave it as is, and he'll go on to our judicial hold status because there is a pretrial warrant out for him.
Thank you, Judge. And Your Honor, I forgot to mention that this case, we actually did a track 1 referral. So there is a plan in place for him. The issue was simply that they were waiting for him to handle his issues. And then it just seemed like that was not going to happen. So they program kept him on pretrial services until he was able to enter the program from the streets. But he was arrested twice on shoplifting charges, and I think that they're keeping him there probably for a minute.
Okay, and this referral is to drug court or to BHTC?
It was a drug court referral.
Okay, well, that may be a great referral for him, and if it's been sorted out as a diversionary referral, it may be that we ought to keep that. I'm sure drug court would still take him, provided that whatever has gotten him locked up continues to be things like shoplifting and not something more serious. And I guess they vetted these charges, because I'm just looking at the charges that are on the calendar. They're not your typical drug court charges, but maybe there's a story behind the aggravated battery that made drug court comfortable.
Correct.
Okay. Ms. Hall, anything you want to add on Mr. Lewis? I think we're going to, it's Mr. Abate, a quick switcheroo.
Nothing to add, Judge.
Okay. Good morning.
Morning.
All right. Position 4 is State versus Malik Cisneros. It's supposed to be on for plea and arraignment. I've got a W on the calendar that suggests maybe there's a warrant for him. The defense attorney is listed as a Lyal Kaba. Is that someone from the PD's office, or is that a private attorney?
She used to be with the PD's office, but she's no longer with the office. His case was once in non-complex. He has been transferred as I can't remember if it was just as a repeat offender or if it was because of a co-defendant. I think it was a co-defendant situation.
Okay. And there's just, we know what the warrant is for Mr. Cisneros?
Yes,
there he is.
This is that.
He's right there. Good morning, Mr. Cisneros.
Good morning. I apologize. I didn't get a notice. But I had court.
All right. Well, we will make sure we've got a good address for you. So, Mr. Franklin, are we waiving arraignment today, or how are we handling Mr. Cisneros' situation?
Yes, we'll waive arraignment, and I'll put in the entry and paperwork today as best I can. I guess I'll write it up and scan it and file it today.
Okay. That would be great. Ms. Nelson, are you in Odyssey or able to be in Odyssey on one of your various screens so we could check Mr. Cisneros' address in the system?
Oh, okay. That warrant is out of Hall County as well.
Okay. So, Mr. Cisneros, you may have a warrant for business in Hall County. You may want to talk with Mr. Franklin, the public defender here on this call, about what's going on in Hall County.
Yes, sir.
All right.
Okay.
So what's the street address for Mr.
Amberline Drive.
I'll try to update the address.
Okay.
Are you still living at Rambley Drive?
No, ma'am.
What about Brewer?
No, ma'am.
Okay, so we need to do an address change, Mr. Franklin.
When I realized Mr. Cisneros wasn't in court, I sent him a text. So I will have him text the address, and I'll do the form in court today.
Okay.
Great.
All right,
Mr.
thank you.
Cisneros, did you get a text from Mr. Franklin? I want to make sure you guys have the right phone numbers.
Yes.
Okay. If you would please send him your current address, then Mr. Franklin's going to file an entry of appearance on your behalf. He'll get your new address in the system, and he'll do the waiver of arraignment, and then we can get a scheduling order in place, which will move your case along. And then again, just this gentle reminder, you apparently have some business in Hall County that you may want to talk to Mr. Franklin about, so you don't get surprised by that.
Okay, and what county is this?
This is Fulton County.
Fulton County, okay.
Where are you right now? What county are you in right now?
No, I'm in Fulton County, but I have an open case in Dawson County as well, so I didn't know which county that I was preparing for.
Okay, busy guy. So that Dawson thing may be what the warrant's for. This is a Fulton County case. You're charged with theft by receiving stolen property. You've got a co-defendant named James Edward Reynolds. That's what this case is about, from 2019.
Okay.
We'll figure out what we're doing next, but Mr. Franklin will be in touch with you. Mr. Franklin, anything else on behalf of Mr. Cisneros?
No, sir.
Okay. Mr. Cisneros, once you get your address to Mr. Franklin, you're free to go.
Okay, I'm about to test him now.
All right, thanks. All right, moving right along. Position 5 is Christina Cameron, a case that I thought we had resolved, but there seems to be a hiccup somewhere in the system. There's Ms. Cameron, there's Ms. Cummings, and there's Ms. Ingram. The three people.
Good morning, Your Honor.
Good morning, everyone.
Good morning, Judge.
Ms. Ingram, why don't you start and let me know what you understand the hiccup to be, and then I'll hear from Ms. Cummings, and it may be that I need to hear from probation as well. It sounds like, if I'm remembering correctly, Ms. Cummings is either a maiden name or the married name, and it got a little bumpy. It doesn't sound like folks were particularly respectful of probation, but I'm sure we'll be better next time as we work through it. Ms. Ingram, tell me what you understand the issue to be.
Your Honor, actually, I'm going to have to defer over to Ms. Cummings because I know she wanted to have this hearing. All I know is that Ms. Cameron had a couple of hiccups when she had to visit probation, and something was put in her maiden name of Vance. But I know when we did the plea, in every paperwork, all the documentation that I've ever had in the district attorney's office has always had Cameron. So I'm not really sure where the confusion came in at.
Okay.
So I'm not really sure.
Got it. Thank you. So Ms. Cummings, should have started with you. Good morning. Tell me what's happening with Ms. Cameron.
Judge, after the plea colloquy, this just became beyond frustrating. During the plea colloquy, Ms. Cameron agreed to report, I believe it was February 7th is what I have in my notes, to probation. She reported, and probation told her they did not have her. She contacted me to say, what's going on? Probation doesn't have her name. I contacted Miss Crawford, which was the probation officer in the plea colloquy meeting in the breakout room. And she said that in the breakout room, she asked Miss Cameron, what was her other name, and she said she told her that she had to report on the Vance. Now, I was in that breakout room, and that part of that conversation did not happen. I don't know if there's a transcript of that, but I don't remember anyone telling Miss Cameron that she had to report as Miss Vance. Miss Crawford informed me that it is probation's policy that if you were ever convicted under a previous name, then on the probation, you have to report under that name. I told her that's not known anywhere that I know of, and I prosecuted prior to being a defense attorney, that someone who has been convicted under previous name, even though the indictment, the plea, all the documentation says her current name, has to report under previous name. So she has been reporting to probation, and probation doesn't know who she is. So I don't know if there is something internal to probation that needs to be corrected. In my emails, I sent Ms. Crawford a copy of the indictment, the plea colloquy, to say everything is listed as Cameroon. So the mistake has to be corrected by probation so that she can report. To the best of my knowledge, she's still listed on the vans and is having a problem reported. I contacted your honor's clerk so that she wouldn't have a probation violation or problem, because Miss Crawford, probation officer Crawford, said that she did fail to report. And I'm like, no, she didn't. She reported, and probation told her, we don't have you anywhere. And to this day, I don't think she's made contact with a probation officer. She was
Okay, well,
required
let's
to
try
pay.
to fix that today. I don't know the origin of the confusion, but I suspect that with Ms. Crawford on and you on and Ms. Cameron on, and not moving folks into a breakout room, but staying right here, we can sort this out. So I'm sorry for any confusion, whether probation felt confused or Ms. Cameron felt confused. I am anxious for Ms. Cameron to start doing what she is obligated to do under the terms of her sentence. And we ought to remove any obstacles that are preventing her from doing that. So let me hear from Ms. Crawford. Good morning, Ms. Crawford. I'm less interested in rehashing what was said in the breakout room. I wasn't there, and I'm more interested in figuring out how can we get Ms. Cameron, formerly known as Ms. Vance, effectively plugged in with probation so she can take care of her obligations.
Good morning, Judge. From my understanding, the name Vance came from a charge that she originally had in Tennessee. It was a forgery first charge that was originated out of Tennessee. And so I think it was transferred here. I'm not sure. And when it was transferred here, it came under Christine Vance. So there's no way for probation to create a name or just reach in the air and say, hey, we're going to name her Vance. So when we went in the breakout room, I said that we have you listed as Christina Vance. So that's nothing that probation created. That was the name that's already in the system. There's the case number, and also copied it and sent it to Attorney Cummins where she could see that it was nothing that I created. It was already what I had in the system for her.
But moving past that, she's not Ms. Vance anymore. Ms. Cameron is Ms. Cameron. And I suspect probation's had to deal with folks who are married or get divorced and names change. What's the most effective way for Ms. Cameron to engage with probation, given that it sounds like all her documentation, in particular, the documentation in this case, they all say Cameron?
Well, it looks like she has reported it. They did a face-to-face. Ms. Vance, did you do a face-to-face video with somebody, Officer Griffin? Because you're saying that she has reported.
They did an intake. I'm sorry. They did an intake. I still haven't met my probation officer who I'm assigned to. I was under the understanding it was Officer Smith. I have reached out and texted several times to Officer Smith. And she told me to come up there and report. So I did go report up there, still did not see Officer Smith. So they had me fill out another intake form.
Where is there when you said you went up there?
I went to the probation office that's located off Citizen Parkway in Morrow, Georgia. Okay,
what county is that in?
That is in Clayton County.
Okay, so you're in Clayton County.
Yes, sir.
Okay, keep going.
So I reported there. I've been there 3 times now. I have filled out the intake paperwork twice now. I have not seen my probation officer. They still will not accept my $500 payment to Mr. Joel Davis. They told me they will not take payments at the probation office. I still have the money order. It's dated for January 23rd, 2021. I explained to them that I have to pay that money by a certain time. It was ordered by the court. They will not accept it. I don't know what to do with this $500 money order.
Okay.
My driver's license was also suspended through a court error, and I've spent over $500 in Uber rides.
Judge, that's the other part of this matter. I guess that's why the frustration got so high. Her license got suspended because of clerk error. I reached out to Ms. Ingram and Mr. Wooten, and they had to file a motion with the Department of Driver Service Court Corrections Unit to fix her license. So her license was suspended for 2 full weeks. So we had to resolve that at the same time that probation was having an issue and she couldn't drive. She had to Uber everywhere to make sure she didn't have another problem.
Sure. Well, I don't know what the situation was with the driver's license suspension. That sounds like a Clayton issue, not a Fulton issue. I'm sorry it happened.
I'm sorry, Judge. I'm sorry to interrupt. It wasn't Clayton. It was Fulton County. The clerk in Fulton County, when they entered the plea, they entered it under the wrong statute. The statute for forgery or something that suspends your license, and that wasn't what she was convicted of.
So it was by operation of law because there was an error in entering the.
Yes.
Okay, well that's frustrating as well. Well, let's figure out what we need to do, and if I need to get involved by reaching out to Clayton County probation, I'll do it. Ms. Crawford, I know that's not your space. You don't work in Clayton County. You're in Fulton. But what's the best way to clear this up so that Ms. Cameron can start taking care of her obligations? And before you answer, I want to make clear, Ms. Cameron, no one's going to revoke anything. It's good that we're having this conversation. You are trying to do what you need to do, and you're being thwarted by, I'll just say in a euphemistic way, by bureaucracy. There's somehow left hand and right hand aren't connecting. My goal is to connect the two hands, but you ought not to be worrying that, the judge is going to revoke me in some way because I haven't paid by deadline X. Under these circumstances, that's not your fault. If what we heard instead was, she's refusing to pay, she's driving a Mercedes, then people get frustrated at you. But that's not this situation. So let's hear from Ms. Crawford as to her thoughts, the best way to resolve this. And I know you're coming at it from a little bit of a distance because, again, it's a different county.
Judge, the only thing I can suggest is that I can call Officer Smith and see, that's the assigned probation officer that I see in the case notes. I can speak with her and see what's the next step. But
okay, why don't we do this? Because I'd like to stay involved. If you could, when you learn, Ms. Crawford, from Officer Smith, how we could solve this, if you could get that in an email to Ms. Cummings, Ms. Ingram, because we got to keep both sides posted, but to me and Ms. Nelson as well, that would be great. Because if in getting that info from you, I get the sense that the folks in Clayton are being a little hard-headed about something, like, hey, it's got to be Vance because it was Vance before. I'll get involved and see if I can help work through that. But I'm also happy to stay the heck out of the way if what we hear from Officer Smith is, yeah, COVID, my bad, we can fix this. I know officers have absurdly large caseloads and they're pulled in many different directions. And it may be that a call from you is just what we need to move this up to the right level of priority for Officer Smith. But I'd like to stay involved so we don't need to get everyone back into court again. And more importantly, we can get this restitution starting to flow in the case. Is that all right by you, Ms. Crawford?
My supervisor will do the email thread because she was forwarded the previous email thread. So she has taken over all email communication. So I will make the call and then I will let my supervisor know, and then you'll get an email from Meriwether.
Who is that?
Alexandria Meriwether, that's my supervisor.
Ms. Meriwether. Okay, I know her.
Yes.
That's great. So what I'll get then is an email, and Ms. Cummings and Ms. Ingram will get an email from Ms. Meriwether that is updating us as to what you learned from Officer Smith. And then if I have questions or need to get in the mix, I can work through Supervisor Meriwether.
That's correct.
Great. I think that's a good next step. So Ms. Cameron, I guess if you're getting any direction from probation to do X or Y or Z, you should try to do that. But we'll also wait to see what we learn through Supervisor Meriwether, and hopefully that will clear it up. If not, rather than drag everyone back into court, I may just work with people via telephone or via email. Ms. Cummings, does that work for you? We haven't quite solved it, but I think we may be heading it in the right direction.
Judge, the only thing I would suggest is if maybe we could do some sort of order or some sort of understanding with probation that her name is Cameron, the indictment is Cameron, the conviction is under Cameron, so probation needs to proceed under Cameron. I understand that her previous name is Vance, that there is a previous conviction on the Vance, but this has nothing to do with Vance.
No, I understand that, and that may be the solution. I'm going to let Ms. Crawford have the conversation with Officer Smith, and then we'll hear what that yielded. And like I said, if I get the sense that there is some kind of inexplicable bureaucracy blocking this from moving forward, I will escalate it as I need to. And if that includes an order along the lines you've described, that's great. But I try not to order people to do things when it doesn't need to be done. So we will see what we learn from Supervisor Merriweather, who I think is going to be real helpful in this situation. And we'll take it from there. But we'll all be in the loop on that one, okay?
Okay, Judge. Thank you.
Ms. Ingram, anything else?
Nothing else from me, Your Honor.
All right, thank you for dialing in for this. Ms. Cummings, thank you. Ms. Cameron, I'm sorry about that driver's license thing. That is a clerical error that was a real hassle. That has nothing to do with probation, but it was sort of a 1-2 punch for you. And that's something that ought not to happen going forward. And Ms. Crawford, I appreciate you trying to sort all this out. Again, I know Clayton is one step removed from your span, but let's see what Officer Smith has to say, and we'll take it from there.
Thank you, Judge. That's all I have. May I be excused?
Yep, thank you.
Thank you, Your Honor.
All right, everyone. Have a good day.
All right, position 6 is State versus Paul Jr. Remy, and that may have been why Mr. Abate was here, but we've got Ms. Hall back. I'm not expecting that we'll see Mr. Remy unless he's one of those people sitting way in the back. Oh, okay. And I don't think we're going to see Mr. Raines. I believe what Mr. Raines shared with us, Ms. Nelson, is that he no longer represents Mr. Remy.
Correct.
Okay. Then I would like to take out a bench warrant for Mr. Remy. Do we do that, or does that need to come from the district attorney's office?
Yeah, and I believe,
Pardon me?
unless there's anything different, I believe that comes from my office.
Okay.
Right. I
Great.
requested, Judge, and they
Okay.
send it to us.
I'll stay out of the mix. This one, the case is a little complicated. I just want to make sure the follow through was done and we got the warrant out there. Okay. Then number 7 is Mr. Dewar, who is Mr. Franklin's client and is in the courtroom. This is on for a status hearing. It was final plea at the end of January. Tell me, either Ms. Hall or Mr. Franklin, why we moved it from final plea to status.
And good morning, Your Honor. 88 Asia Besa as well.
Oh, hey, good morning, Ms. Beza.
Morning.
All right, so your case, oh, look, it counts 2 and 3 and 4. There we go. Okay. But you may not remember as much since it was January of this year. Mr. Franklin, why are we here on a status hearing?
Yes, Judge. We've been in negotiations about a potential virtual pretrial intervention agreement. At the point in time that we continued from the January court date, there was one particular issue that we were working around. The complaining witness and Mr. Dewar shared children together. Time we were trying to figure out language that would ensure that Mr. Dewar is able to still be a father to his children, but acknowledge the stay-away conditions that the state desired. We've talked and talked. We got really close, but it doesn't appear that we're going to have an agreement.
Okay. So, excuse me, ought we to move this to a trial calendar?
Yes, Judge. One question, and I've given Mr. Dewar my best interpretation of this all. he was curious as to when the earliest point in time he would be able to have a trial is. I explained to him my understanding that given the backlog, that the most likely course of conduct would be that persons who are in custody and with more serious charges will get tried sooner than later. And being a person with a not quite a serious charge relatively and being on bond, that it could be upwards of a year. But I'm not sure. I didn't want to speak out of turn, but he did want for me to try to get an idea from the court.
Sure.
What the timeline looks like.
The answer is we're working on ideas that would allow us to move forward with bond cases as well, so that the bad news wouldn't be, well, we'll see you in 18 months. Certainly the priority is cases where a defendant's been in jail for more than a year. And sadly, we have a whole bunch of those, as you know well, Mr. Franklin. But we are exploring options that would allow us, maybe using senior judges, to try bond cases away from where we've got the secure courtrooms, because bond defendants pose a less complex logistical issue for the sheriff. They walk in, they walk out. And so maybe that means using the Slayton building for some trials. There's legislation that will hopefully pass that will authorize counties to use non-county facilities for trials. There's an obscure statute that says you can't use non-county property for court, absent a whole bunch of hoop jumping. But they're trying to amend that. And it looks like that'll pass, which would open up a whole nother vista for having civil trials and maybe bond criminal trials away from the courthouse. That's all developing. So the best I can say is we're working hard to create a scenario whereby this summer we might be able to look at the bond trial backlog. In this case, being a 2018 case, would be a high priority. Mr. Dewar has been under charges now for, I don't know when the indictment was, but it could be upward of 3 years. And that would put him towards the front of the line, assuming we could create a bond line. If those efforts are unsuccessful, then I think your estimate is pretty accurate, because right now we're doing only one trial at a time, which will take forever to get through the 15 judge backlog. When we can start doing multiple trials, then we could focus on our docket, but we've got lots of jail cases that we would deal with before we'd get to Mr. Dewar's. So let's all think positive thoughts about some of these alternative solutions for bond cases. And I'll certainly keep the lawyers posted as we work on that, and then they can let their clients know about that situation.
Now, may I make a quick record?
Yes, ma'am.
I just want to
turn to you, but before you do that, I just want to make sure, Mr. Franklin, do you or Mr. Dewar have any questions about what I just described? Okay, so you've heard the defense's perspective, Ms. Beja. I'd like to hear the state's perspective on where we are with Mr. Dewar's case.
We were negotiating with the help of ADA Hall, as this was her case prior. It's called a VPTI, like a virtual PTI, where for a year, so he would have to stay away from the victim for a year. Obviously, if he wanted, contact with the children, that can all be worked out through family court or civil court, not sure what it's called here. And he would have to do a program, I think it's a 16-hour domestic violence program and an anger management program. And at the end, the case would be no pros. And we're giving him a year to do the program, even though it probably wouldn't take that long. I'm not sure, it depends on how fast he does it. And that was the recommendation that they worked out. And that was the recommendation being offered today. However, if he does not take it, then our recommendation is off the table, because I do feel like that is a fair recommendation. The victim, who is very cooperative, is on board with the PTI and giving him the opportunity not to have an additional criminal record or criminal record after this. She would like full stay away forever. That's not reasonable. So we were saying possibly a year. Obviously with the kids, you know, they can work that out through whatever courts. So having the recommendation be, you know, with the virtual PTI, subject to any kind of civil or family court proceeding is fine, which would take care of that. But I guess he doesn't want it.
Yeah, the breakdown was, our final request was, could it be no price after he completed the classes? And that's where the state kind of drew its line. And, you know, I'm not here to comment on the state's thought process or strategies. That's just he was willing to do the classes. It's just that the year period posed other issues. Because as much as she wants to stay away, they do have contact through text message, at least casual contact. We could talk about it for an hour, honestly. But I explained to him that this essentially was an offer that is good up until today. We had that conversation, and the open nature of the case has presented some issues with other employment opportunities. He currently works as a kitchen aide of some sort at Arizona restaurant out in Lithonia or Stonecrest area. CDL, he hasn't been able to kind of get back on that for about 2 years because of the openness of the case. So he was anxious to kind of, you know, improve his station in life a bit. But we negotiated, we understand, you know, the state wants the time for whatever reasons.
Okay. Well, my only observation is Mr. Dewar, I assume a condition of his bond is that he stay away from the victim. And so he's going to have to stay away from the victim even longer than what was offered if what is likely to occurs, which would be he cannot have a trial until 2022, 2023, because he's out on bond. I trust you shared that with him, Mr. Franklin, but I would
have these conversations
if I didn't flag the fact that his very understandable resistance to having the case remain open for a full year, even if he met the other requirements, is going to happen by default if you all remain at loggerheads. But if he's processed that and wants to gamble that maybe he could get a trial within a year, which strikes me as exceedingly unlikely, then he's making the right call. All right. Well, then what I will do is move Mr. Dewar to a trial calendar. I think he may be listed as a case on a calendar. Poor Ms. Nelson has to pull together calendars and then discard them each month as we continue to remain under these conditions. And so I don't want anyone to get the wrong impression. I think there is a calendar that Ms. Nelson has pulled together. It's invisible outside of Odyssey, but it lurks within Odyssey. And Mr. Dewar's case may be on a July calendar. That does not mean that we would be able to try Mr. Dewar's case in July. That's not happening. At least I wouldn't be able to do it, because if I'm trying cases in July, it's going to be folks who've been in jail, maybe as long as Mr. Dewar's been under indictment. So as long as folks understand the landscape, that the most likely outcome, if there's going to be a trial, is that it is further away in time than the dismissal of Mr. Dewar's case if he entered the VPTI, then I feel like we are all understanding each other, and we'll respect Mr. Dewar's decision. And
just 1 second, Judge.
Okay.
She said you could complete it right away. You don't have to wait a year to complete it, but it's still, the case will not be dismissed for a year. So she said you can complete it. You can find 24 hours next week and complete the classes, but you won't be able to have it actually checked off and dismissed until the year passed. And so you heard like what I kind of try to tell you is that the goal of the trial is to get to a particular result. We know that we have achieved the result. And then the question for you is like, well, what's the quickest way to get there? And so what you're kind of doing is you're taking a longer route for a more uncertain outcome. So
Correct.
Mr. Franklin, do you want to chat with Mr. Dewar a bit?
Yeah, we'll chat a bit before we like totally leave. I have his basic cell phone number. I think part of the conversation that he and I had, kind of hearing it from the court in terms of the timeline and that kind of thing. We'll have another quick thing, and I'll try to finish this discussion before the close of the calendar. But for now, my initial announcement stands, and I'll amend it in a few minutes if necessary.
Great. So we're going to turn to Ms. Rockwell's client that may be a plea. So you've got a minute. You go talk with Mr. Dewar. Ms. Beja, as long as we can track you down real easily, you're welcome to sign off, or you can just sort of listen in the background. But
I'll just stop my video and I'll be here because I'm in my office. So I'll just do work.
Great. Okay. Thanks.
Thank you.
All right. Mr. Kimber, if you are here, if you could come on up and sit at defense counsel table, please. Ms. Rockwell? Oh, she had to step away. Ms. Hall, what was going to happen, do you think, with Mr. Kimber's cases?
I'm sorry, Your Honor. Maybe just a status for it to go to final plea. Me and Ms. Rockdale talked, and I gave her an offer on both cases. These are cases that were transferred to us. So I gave her an offer, and I don't think they're taking that offer. So unless we're doing a non-negotiated plea day, which I haven't heard of, it may just be final plea.
Okay. Well, we'll see. Hopefully Ms. Rockwell will rejoin us shortly. Judge Leffridge's staff attorney was with the public defender's office. And so Judge Leffridge, is having to send a lot of cases out. You should know, since you worry about your case count, we send something back. So we keep it balanced. I don't know what case you lost, but Judge Leffridge got a present in return.
She did. I saw that yesterday.
Okay, good. That gets us to David Carr. Did we get confirmation? Was he a PTI? Tell me. I know Mr. Jones isn't on the call yet, but you can tell me.
It was a null price, Your Honor. I sent over the null price. I believe that was filed already.
Yes, it's been filed.
Okay.
They were both excused.
Great. That was my recollection. I think that's it, unless I didn't print out another page of the calendar. Did we have any other cases, Ms. Nelson, or it's the Carlos Kimber is the last piece?
That's the last piece.
Okay. Well, Mr. Kimber, if you don't mind sitting tight right there, your lawyer is coming back. She had another Zoom. She's a popular lawyer, and she had to, I think, check in another courtroom. So we will sit tight to get her back on, and we'll also wait a little bit while Mr. Franklin talks more with Mr. Dewar about a year versus a year and a half. So I'm going to turn my video off, but I'll be right here, and we'll plug back in. Ms. Crawford, if you don't mind staying on, because we need to figure out if we're going to be doing something substantive with Mr. Kimber's case. Thanks. Ms. Patel, do you have anything else? You're welcome to stay on.
I do not. I was just going to ask if I may be excused.
Okay. Yeah, both Ms. Patels, I think, are free to go.
Thank you, Judge.
All right.
Thanks, Judge.
All right. Bye-bye. So, Ms. Nelson, I've got a question for you. Like I announced at the beginning, this is my first court from not in court. And the lawyers' microphones are really loud. And Mr. Franklin sounded like he was yelling. I know he wasn't yelling. Is it usually that way, or have they messed with the settings?
No, they're not usually loud like that. I thought it was just because Mr. Franklin was sitting close to the mic, but it's usually not that loud.
Okay. Then they may have tweaked it some way because I told them I wasn't going to be there. Who knows? But I just felt bad for you and Ms. Rivers because it seemed like everyone was.
Judge, the sound usually comes from the litigation manager. I noticed it's coming from the podium now. That may be a reason.
Oh, yeah. And they did that yesterday with drug court. and it was real hard for folks to hear me. So maybe we could get it back to litigation manager. That's where it's supposed to be.
Yes.
Because then if there were a human in court at the litigation manager desk, he or she could be messing with things if they needed to adjust things.
There's been a problem with the litigation manager. It is not dropping down as a selection. I was told that they were going to run a cable to the computer, and that hasn't been done yet. I do not believe so. I have been requesting on my, when I ask for video setup, I've been letting them know that I'm not able to select litigation manager. So they're aware of the problem. Maybe they just haven't been able to fix it.
Okay, well, I'll reach out about that as well, just to see if we can get them focused on it. I know this trial going on in 1D has consumed a lot of their energy, but that should end to jury has the case now. So that should be less of a time sink for them. All right, I'm going to become invisible. I'll pop back on.
Your Honor. Can you hear me?
Yeah.
Oh, okay, sorry. Me and Miss Rockwell were texting. She's still in her hearing, but she wanted me to ask if she can have a motions date. So maybe we can get a scheduling order.
Okay.
She said I'm sorry. She said she thinks she has all the discovery, but I can just look. I'm sorry, you can't hear me?
No, I can hear you.
Oh, she said she thinks she has all the discovery. I'll go through the file and make sure, but she wants a motion date. So I guess we can't go to a final plea so she can have opportunity to file motions.
Okay. And your review of the docket, is that sort of where we ought to be? Like it wasn't already on a trial calendar for, I don't know if this was like Judge Farmer's case originally. I think Leffridge inherited Farmer's docket.
Right. I didn't see that it was scheduled for a trial or anything like that.
Okay. So Mr. Kimber, you're going to be able to leave in just a sec. It sounds like Ms. Rockwell is stuck in this other court. And she wants to make sure that you and she have all the discovery in your two cases. You've got one case that charges you with marijuana and cocaine, and the other is just cocaine. Got to make sure she's got discovery, and then she may want to file some motions about what the police did or didn't do or who knows what. So I'm going to have Ms. Nelson enter a scheduling order in your case that will give the state a little more time to make sure they've given everything to your lawyer. It'll give your lawyer a little bit of time to file motions. And if there are motions, we'll get you back into court along with Ms. Rockwell, and we'll have that motions hearing, okay?
Yes, sir.
Any questions about that?
No, sir.
Did you get something in the mail telling you to come to court today?
Yes, sir.
Good.
Last
So
week.
we got a good address for you. If you move, you got to let Ms. Rockwell know so she can get it changed in the system, okay?
Yes, sir.
All right, you're free to go. So what case did you think maybe was going to plead today, Ms. Hall?
Position 2 and 3 were the ones that me and Ms. Patel worked out, but she wasn't sure if her clients were going to show.
Got it. Okay. So if because one guy is going into drug court maybe,
right,
and then you've worked something out with Ms. Hines if we can track her down.
Yes.
Okay. Got it. All right. Well, thanks for your help today.
You're welcome.
We're good. Whenever you're ready.
Okay. Yeah. After further discussion, we are going to accept the agreement, the negotiated agreement. So I have a form that I drafted in my office. I haven't emailed to Ms. Hall and Ms. Baser yet. Essentially, it acknowledges 16 hours of domestic violence must be completed, 8 hours of anger management. There is a mental health evaluation that the state requests to be done, and he must follow up with any recommendations that flow therefrom. And a stay away order that allows essentially for a intermediary to conduct drop-offs and pickups and exchange of the children, that kind of thing.
Okay. That seems consistent with what Ms. Beja said. She'll obviously need to see the proposal that you've got. My request would be, since we've got everyone together, rather than it be this amorphous domestic violence program, there are any number in the greater Atlanta area family violence intervention programs. Those are the 16 hours. Those are certified. The Georgia Commission on Family Violence helps certify them. They're the sort of the gold standard. And so what I'd like the order to say is that Mr. Dewar will complete an FVIP of his choosing. There's not just one, but I don't mean to throw a wrench in this. I just think that's a cleaner way to do it. And it gets us the level of training that everyone ought to be comfortable with, and counseling that everyone ought to be comfortable with, because there's sort of a standard curriculum. And as I said, it's something that's governed or regulated by the Commission on Family Violence.
Not offer, I guess, pushback, but ask the court a couple questions. So that's something that we initially looked into. So the family violence intervention programs are 24 hours. And the time is the difference because 16 plus 8, of course, is 24. However, there's a different cost range that is involved with the family violence intervention programs. And as best as I was able to determine, it's anywhere between $30 and $50 per class, versus the other programs being kind of pay up front, during a set of times, being able to be completed online.
So it's been a while from when I was working with the Commission on Family Violence, but it was my understanding that they had FVIPs that accommodated folks who weren't able to pay as much as you described, because it wasn't meant to be, one, a fine, or two, out of the reach of folks who might benefit from it but could not afford it. So it may make sense to reach out to just call the folks at the commission and they could answer the question. They have an executive director and a phone number, and it may be no longer do they offer something like that, which would be surprising and disappointing. But I don't mean to impose costs that are unreasonable on Mr. Dewar. It involves anger management. And so I think if the understanding from both sides was that Mr. Dewar would do an FVIP, then he would not need to do an additional 8 hours of anger management. The 24 hours of FVIP would be a substitute for 16 plus 8. And it would be, as again, it's the gold standard of the kind of counseling that we want in this state.
Agreed.
So if you don't mind checking with the commission, the DA's office has a friend there they could reach out to, because Ms. Ross is the executive director. But they ought to be able to answer that question of whether there's a sliding scale FVIP that would be able to accommodate Mr. Dewar's financial resources. And if the answer is no, and the only ones are too expensive, then I'll get out of the way. But I'm going to lean us in that direction if it is financially viable.
So, 1 second.
So they're saying as opposed to doing these two separate domestic violence or anger management class, there's one course that is a better course that the judge recommends we include instead of these two different ones. And you still have the year to complete it. Okay.
Yeah. I think we have the outline of an agreement in place then. It's based directly about this because I've mostly been negotiating with Ms. Hall. Mr. Dewar and Ms. Lett need to to arrange the drop off of the children. So I don't know if we can make contact and limit contact to discussion of, hey, kids or that kind of thing, or that's the gray area that's not as big, but yes, Ms. Besa.
We can't hear you, Ms. Beza. Nope.
Okay, how about now?
Yep.
Yes.
I don't want to get too much into this as this is criminal court case, but are you saying that he has plans to go to family court or civil court to arrange custody, visitation, and then through that, finding an intermediary? Like, I don't.
So I'm
because
gonna
there's an order in place.
Outline a little bit, but in Georgia, it may work a little differently than the jurisdiction from which you're coming.
New York.
Typically, when we sort these kinds of cases out, it's not involving a parallel court proceeding. Sometimes it does, but typically there is an understanding that Aunt Jane is going to be that designated intermediary or Uncle whomever. And that would be, that's often the condition in a bond, that yes, you can see your kids, but the way you see your kids is you arrange it through person X. And I would hope we could do the same here. That doesn't mean y'all can't go to family court or get defects in the middle, but that is a layer of complication and frankly delay that Mr. Dewar might not be as interested in if he is as anxious as he describes to have this 1 year clock get ticking. So that he's able to move in the directions he understandably wants to move in. So I'm not requiring it to be one way or the other. It sounds like Mr. Franklin and Ms. Beza can have a good conversation. We don't need to have it in this setting, especially with the microphones acting in the weird way they are.
I can reach out to the victim today about an intermediary. You're right, it is different and I'm getting acclimated. And so no need to get family or civil court involved if we don't have to. So I'll reach out to her today because I know he drafted the order and kind of figure out who this intermediary can be, and then we can put the name in the order and move on.
Great.
Yeah.
And then if you guys can sort out that FVIT piece, or maybe that's been accepted as a substitute for the other things, get me what you all have agreed to. I'll sign it, and Mr. Dewar will be off and running. I want to make sure that we do nudge it forward. Do we put this on another calendar, just a real short fuse calendar a few weeks out, or do we just agree that you'll get something to Ms. Nelson by date X and we'll agree on the date right now? I'm fine either way, Mr. Franklin.
I think the latter is sufficient if that's okay with Ms. Besa.
Yeah, I think if we just sign off on it and then give him the opportunity to do his classes.
Okay, so today is March 25th. What's a good deadline for Ms. Nelson to be poking at you guys if she hasn't seen anything?
Let's say April 1st. I know April 2nd things are gonna change a bit for Ms. Besa after that. So honestly, I think it's something we might be able to kind of figure out today. Like I said, I've drafted something already. I just hadn't sent it over because we had not officially come to an agreement, and I didn't want to accidentally have to send in and get out and stuff. So
yeah, I'll reach out to the victim
update
today.
by April 1. So Ms. Nelson will be reaching out. Ms. Beza, how will we learn who will be managing your caseload as of April 2?
I sent it to Ms. Nelson this morning, and I CC'd. I didn't CC you, Your Honor. I'm sorry. I didn't know if that was appropriate, but I CC'd the public defenders and everybody.
That's fine. Ms. Nelson is more than adequate. She is a good sharer, so I will learn that. And frankly, she's more important than I am. You could tell me, and that's not going to fix calendars.
That's fair.
So if you tell her, then come April 2, your substitute, not replacement, but substitute, will get notice, and we will wish you
Michelle
the very best.
Sims.
How long do you plan on being gone?
3 months.
3 months. Wow. Well, good luck with all that.
And
Is
I'll be
this
back.
journey number 1, or have you already had this journey before?
Number 2. The first is 18 months, so number 2.
All right, that's back to back. Well, good luck with all that. If we don't see you before April 1 or April 2, and we will work with your substitute in the interim.
Yeah, ADA Sims, Michelle Sims.
Okay, great. Thank you, Mr. Franklin. We'll look for that order. And I think that takes care of the calendar. Ms. Hall, you have anything else?
Nothing else, Your Honor.
Okay, Mr. Franklin? All right, Ms. Beza?
No, Your Honor.
All right, thank you, everyone. Thanks, Ms. Crawford, Ms. Rivers.
Thank you, Judge.
You're welcome. Have a good day.
And good luck
Thanks,
with
Judge.
Ms. Cameron, Ms. Crawford.
Thank you.
All right.